Today's video is going to be a little bit different. I'm actually going to do a reaction video to the law that just passed in South Carolina. It's law H754, which makes the act of wholesaling real estate in South Carolina illegal. And I'm not even talking about, oh, you shouldn't do it, you get in trouble. Absolutely illegal. And so I'm going to watch this video by a guy named Gary Pickren, who we actually used to close our transactions with in South Carolina. They have over 30,000 transactions that they've done. And so this guy knows what he's talking about. And he actually was like in the room as they created this legislation. So this guy knows what he's talking about. We're going to go through and see, what is he saying about this? What does it have to do with us and what we're doing? And then even like, how am I going react and respond based off of this information? It's not even like, it's like, oh, this kind of sucks. This is really bad. The lives of people who ran a wholesale company or do run a wholesale company, support their family, support their employees, completely changed now. They can literally not do what they were doing before unless they pivot to a different way of doing it. So it's really interesting. Let's go ahead and dive in. Now, Gary knows exactly what he's talking about. Gary is extremely qualified. And I know because I work with him, he has done over 30,000 transactions in the state of South Carolina. So I'm excited to hear what he has to say about this.
Hey guys, if you're a real estate investor in the state of South Carolina, I'm sure you've heard the rumors that wholesaling is illegal or about to become illegal in the state of South Carolina. It is now illegal in the state of South Carolina pending the signature of the governor. On May the 9th, the Senate passed the bill that had already been passed by the House that essentially outlaws wholesaling. You doing so through the South Carolina regulation or statute that regulates South Carolina's real estate agents.
Dang, that's crazy. So went to the Senate, went to the House, got passed. So really it goes to the governor's table and it's semantics at that point. As soon as it gets to his table, he just signs it. And then as soon as he signs it, it is illegal. So crazy, it's gotten through. So it's pretty much a done deal at this point.
Real estate licensees at South Carolina Code 40-57. My name is Gary Pickren. I'm a real estate lawyer, been practicing law in the state of South Carolina since 1995. I've done over 30,000 real estate closings. Dang. I am a licensed real estate broker. I'm also a licensed and certified real estate instructor, as well as a real estate commissioner for the state of South Carolina.
There you go. So this guy, and I knew he was a commissioner, but he was one of the 9 people that sat in the room a year and a half ago that began the process of making wholesaling illegal. They sat in, they listened to this case of this lady getting screwed over by a wholesaler. And then at that point, that essentially put all of this in motion. It outlawed it at the time. And then now we're at the place where it's illegal.
South Carolina. So let me give you an update on how this law came about. So as you will see here, this law is H4754. As I mentioned, it passed in the House as well as the Senate on May the 9th. It has now will become law upon the signature of the governor. Once the governor signs it, it immediately becomes an effective statute. So let's see how they handled it. It's actually quite brilliant what they did in doing this, because in order to regulate wholesaling, they had to bring it under a statute. And then once they brought it under a statute, then they could regulate.
Yeah, that's crazy. So they define it here and tell you exactly what it is. So this is what wholesaling is so that they can regulate it. That's nuts.
So let's see how they did that. What they did is they defined wholesaling as meaning having a contractual interest in purchasing.
I notice it says contractual interest, not like equitable interest or equitable ownership. It says contractual interest here.
Residential real estate from a property owner, then marketing the property for sale to a different buyer prior to taking legal ownership of the property. We know that to be wholesaling. That's not any weird definition. That's exactly how we understand wholesaling to be. That's how you understand wholesaling to be. I've already had some people saying, I don't market the real estate, I market the assignment. It's not going to work. That's just semantics. Your bottom line is you're still underlying marketing the property. So that's not going to work.
Yeah. So that actually takes out like everything. That takes out novations, right? Because like, even if you have a power of attorney, even if you have a listing agreement, net profit sheet, it doesn't matter what you have in here, or if you're going to do double closing, because technically if you're double closing, then you have to, in order to close on that same day, market the property before you actually own it. And so you could technically get in trouble. Let's say there's an investor you're working with, a buyer that you don't really know. They could technically report you, or a title company can technically report you for marketing that property, because you'd have to market that property to bring a buyer that same day. So essentially, you would almost have to do some sort of gap closing, where you close on one day and then maybe 2 weeks later, a month later, you close on the back end to the seller to almost prove that were not double closing it. So that means you'd have to come up with the capital to be able to just buy the house.
All right, next it says advertising or marketing real estate owned by another individual or entity with the expectation of compensation falls under the definition of broker and requires licensure.
Okay, so they're like, hey, this is crazy. So they put it into law, they defined it, and then they said, all right, brokers, since you're getting compensation from this, that now makes you a broker. And so what happens is they defined it so that they can regulate it with brokers, because I'm pretty sure they go on and it talks about how agents and brokers cannot wholesale. And so they're defining it and then they're categorizing it and saying, hey, brokers, that would make you a broker and you need a license. And then if you have a license, you can't do it.
This is the brilliant part of it. Now what they've done is they defined wholesaling, and then they said if you want to wholesale, you have to be a licensed real estate agent. Thus, wholesaling is brought under the statute, so now they can regulate it. If it's not part of the statute, they can't regulate it, but it is now brought into the statute because in order to participate in wholesaling through the marketing and advertising of real estate, then it can be regulated. Understand that advertising and marketing is basically anything to do with trying to sell the property. The Real Estate Commission has already opined. That includes social media, Facebook groups, even a private Facebook group, standing up in front of a group of investors and pitching the property, calling your list of investors and saying, hey, are you interested in this property? Anything like that is marketing and advertising that property.
There it is.
So I want everybody to understand that, oh, well, I don't market on MLS or I don't put it on social media is not going to be a defense. Marketing and advertising, as the Real Estate Commission has opined on at least 2 occasions, is anything that you basically do to attempt to try to sell the property. So it's broad enough that it's going to incorporate pretty much everything that you do as a wholesaler. Now, how do they then prohibit it? Then they bring in this statute here, 350A,
and because
a real estate brokerage firm and its subagents are prohibited from engaging in, representing others in, or assisting others in the practice of wholesale.
You can't even, so like this is where it takes novations out. If they're assisting people that are doing this, you can't list anything if they don't own it.
So what this has done, we've defined wholesaling, then it says you have to have a license, brings you into the statute, gives the jurisdiction to the state of South Carolina to regulate you. Then they regulate you by saying you cannot do it. You can't engage in it, you can't represent others in it, you can't assist others in it. So essentially at that point, wholesaling is no longer allowed in the state of South Carolina. There's no ifs, ands, or buts about it. It doesn't matter the semantics of it. It is now illegal. Now, I've had some people saying, if your law firm won't do those closings, I'll go talk to another lawyer. I'll get somebody else to do it. Understand, it is illegal for a lawyer to assist somebody in violating a state law.
That's going to be, I think that's going to be the thing that wipes out wholesalers the fastest, is that there's not going to be title companies or lawyers that are going to do these closings anymore. Gary told me, he said, I told all of my wholesalers, hey, you got 2 weeks to finish out and close all of your deals. And after that, we are no longer closing any more deals in South Carolina, because then we would be participating in an illegal act, literally. And as lawyers, they'd be reported to the bar, all of those things. And so they cannot do that. It'd be crazy.
Under our rules, if we assist you in violating something that is illegal, then the lawyer themselves is subject to discipline by the Supreme Court. So once the lawyers understand and know that wholesaling is now illegal, and they will understand this soon because it will get sent out through the bar, it'll also get sent out through the title insurance companies, that once this is notified to the lawyers, then lawyers will not be able to do wholesaling. So wholesaling in South Carolina, upon the signature of Governor McMaster, and again, we believe he will sign this bill very soon, wholesaling in South Carolina will no longer be legal.
Actually, another video that he just sent out, I think because people are talking about it and there's still a lot of misinformation. I don't know what this video says at all. So let's just see what he says.
Hey guys, it has taken less than about 1 hour for a lot of misinformation to work its way through the investors' Facebook groups, private groups, their chat rooms and things of that nature. And a lot of our investors are already calling us and emailing us asking a lot of questions about this law and having these ideas of how they're going to work around it that really are kind of nonsensical. So I wanted to address some of the things that we're already seeing and comments that are being made that just aren't true. My name is Gary Pickard. I'm a real estate lawyer here in South Carolina. I've been doing this for 30 years and working with investors, done over 30,000 closings. What I think everyone needs to understand is the statute has defined what wholesaling is. And I think it's pretty clear what wholesaling is. But the problem is a lot of these investors are sitting telling me 2 things. Well, It's not, it's only stops you from marketing and advertising. But when you look at that component of wholesaling, it's the most important component of wholesaling, because you can sign the contract, but how are you going to assign the contract unless you market it or advertise it to somebody else? And again, the Real Estate Commission has been very clear and has defined marketing and advertising in real estate includes pretty much anything, any effort to sell the property, talking in a group, posting on a private Facebook group, having a webinar, talking to people about it, putting it on social media, sending text messages out. All of that is considered marketing and advertising. So that's going to be a non-starter. You're not going to be able to get around this, oh, I don't wholesale because I didn't market and advertise it. I went to an investor group and told them about it. Well, that's marketing and advertising it under the statute. Secondly, people are saying, well, I don't market and advertise the property. I market and advertise the assignment. I market and advertise the contract. That's a distinction without a difference. That's not going to fly. It's still the same thing. You can say it's be like saying I'm not a car dealer because I don't sell cars. I sell car titles. It's the same thing, guys. And a regulatory board is not going to look at that as any distinction at all. But the bigger problem for it is that ultimately what it comes down to is that the closing attorneys are going to be the ones who have to take the risk.
Yep.
Because ultimately the closing attorneys are the ones who have to do the closing, and they have to sign the settlement statement that everything's true and accurate. Mm-hmm. And so if they are allowing you to wholesale, they subject themselves to possible punishment by the Supreme Court of South Carolina. Lawyers are not allowed to assist clients in breaking the law. So if it's illegal for a client to wholesale and the lawyer assists in that, they can also become responsible for that action as well. Secondly, lawyers may not turn a blind eye. I can't say, well, it might be wholesaling, but I'm not going to ask any questions, so I can just go ahead and close it and plead ignorance later. So it's going to be very difficult for a lawyer to do a transaction in which there's an assignment without asking questions to ensure that that's not a wholesale deal. Mm-hmm. So there are times that there could be wholesale deals, and we'll talk about those in a second. But the other issue that you have as well is the statute allows for civil actions for violation of the statute. So a seller finds out that you wholesaled the property, in their opinion,
sue you right away.
Plaintiff's lawyer will now be able to file a lawsuit against the wholesaler, as well as the law firm for assisting in the wholesaling. And so now the lawyer is going to have risk of not only a disciplinary matter with the Supreme Court, but also the risk of a civil action as well. Understand, and I want to make sure we are clear on this, is there are many times that you can have an assignment where it is not wholesaling, where the closing attorney would be able to do the closing. For example, if I own 5 LLCs and I sign the contract in the name of ABC LLC, and I decide I don't want to put it in that company's name, I want to put it in XYZ LLC, I can do an assignment to that. That's clearly not a wholesale. I didn't market and advertise it to myself. I didn't market and advertise it from ABC to XYZ. That's not wholesaling. I could buy the property, be under contract, lose my job, and then decide to assign the contract to my brother, and he will close out the transaction so I don't go into default. Clearly not wholesaling. The bottom line is it's going to be a factual evaluation. And so in those situations, what I believe will happen is that closing attorneys, when you say, hey, this isn't wholesaling, here's why, at my firm, we would write that up, have you sign it stating that everything that you have stated in this is absolutely true and accurate, and you will indemnify and hold the law firm harmless if your information has been false. So if you come to us and say that this is not wholesaling because I'm just moving it from my one LLC to my other, which I'm still a majority owner or some type of owner there, that might be one that we can go ahead and close. But if you come in and say, well, I bought this property, went under contract, and then I marketed it, or I didn't market it, I just told other investors about it, now they want to buy it, that's a wholesale deal. And the lawyer would not want to, most lawyers aren't going to feel comfortable doing that transaction. So that's where all these workarounds and these ideas are probably not going to work in South Carolina. So wanted to bring that additional information to you. As we have more information available, we'll bring that to you as well.
Holy smokes, that was crazy, right? So to listen to that, to sit there and see, okay, can't do novations, can't double close, can't wholesale. What is there to do? And this is where I've been talking about it for a while. The installment method is something that we can do because we are actually taking equitable ownership, not contractual interest over a property. We actually have equitable ownership, and then we are marketing it. And then we are putting it out there because we actually are listed as owners on the title. So if you guys are interested in the installment method, check the link below. There is a free training that you can go on there, check it out, see how this could be helpful for you and your company as you can continue to be able to do this. You could be able to send to cash buyers, put it on the MLS, put it on Investor Lift, do a flip, all of these things without having to buy the property or put down the money to purchase the property, just to be able to make some money on these transactions. So I would highly suggest you guys checking out the installment method, joining the community down there. There's so many ways for you all to be able to grow. Let's grow together, because I think these regulations, this is just the beginning as it continues to move forward across the country. So no matter what state you're in, regulations are coming. It's going to look different in each state, but the regulations are coming. And so how could you be prepared for that? Just like I am prepared in South Carolina, I'm prepared if this happens in North Carolina. I actually am going to be moving into states with the stricter regulations using the installment method. So it's going to be really interesting to see what happens in the future as this continues to roll out. But that is my reaction to it. I'd be really interested to hear what your thoughts are. Make sure you comment down below because I'd love to hear it. Thanks so much. I hope you have a fantastic day.